The case I will be talking about is the Equal Employment Opportunity Commission versus Abercrombie and Fitch. Abercrombie and Fitch is a fashion retailer known for fun, trendy clothes. They're sister company to Hollister and Gilly Hicks, and their headquarters is based out of New Albany, Ohio. The Equal Employment Opportunity Commission, also known as the EEOC, is a federal agency that enforces discrimination laws. They take action to address discrimination and systematic racism, as well as working with other federal agencies such as the FEPA. They are responsible for enforcing federal laws that make it illegal to discriminate against a job applicant or an employee because of the person's race, color, religion, sex, national origin, age, disability, or genetic information. Some background information on the case. In 2008, Samantha Eloff applied to an Abercrombie and Fitch Kids in Tulsa, Oklahoma, but was denied because of her hijab. Abercrombie is known for having a strict look policy on what employees wear, and per the Abercrombie policy, all store employees must wear clothing that is reminiscent of the company's style in an effort to bolster the store's brand. This policy also includes a ban on caps, although this term is not clearly defined within the look policy. The EEOC ended up filing a lawsuit on her behalf in 2011 after a 3-year investigation. The basis for the lawsuit was a violation of the Title VII Act of 1964. This prohibits employers from refusing to hire applicants based on religious practices. The courts involved, the U.S. District Court in Oklahoma got involved in 2011. The court ended up ruling in favor of ELOF and the EEOC. Abercrombie then appealed this ruling and it was brought to the 10th Circuit Court in 2013. They did rule in favor of Abercrombie, and at this point, the legal argument had shifted. The new legal argument was not about the fact that Abercrombie did or did not refuse to hire her because of her hijab. It shifted to whether a potential employee must inform an employer about religious accommodation for the Title VII Act to apply. So it depends on whether or not they have to disclose their need for religious accommodation or not. And because of this, it then went to the Supreme Court in 2015, and they ended up ruling in favor of ELOF and the EEOC. The final ruling, it ruled 8-1 in favor of ELOF and the EEOC. Justice Scalia gave the court opinion, and he said, an employer may not make an applicant's religious practice, confirmed or otherwise, a factor in employment decisions. The motivation is what matters under Title VII, not the knowledge of need for religious accommodation. Under the Title VII Act of 1964, companies now can be held liable for discrimination if they have a suspicion that someone might need accommodation, no disclosure for it is needed. Abercrombie did end up changing their look policy after the final ruling to allow for more flexibility and freedom with the dress code. Since then, they have reworked policies and redefined their brand image. The significance of this case changed the way that religion is included in the workplace. Religion is now protected under federal law in the case of discrimination. Lots of media attention was brought to the case, and it was widely spread over social media. Some of the biggest news outlets that reported on this case were CNN, the New York Times, Forbes, and Bloomberg. Some of the big topics that was talked about over social media about the case was work diversity, harsh corporate policies, and religious freedom. Reform was brought to many companies because they had to run through new diversity education classes, improve their legal training, and improve the HR department. This case reminded employers and employees that federal laws protect religious rights. Protecting this right is not dependent on filing a formal request anymore. Lots of companies did have to go in and change their policies in order to appeal to what this case signifies. And then these are my references.